Good morning, everyone. Today is Tuesday, August 20th, 2024. The time is 9:31 a.m. This is the status conference in the matter of Robert Devine, case number 2024-004-S, before the Massachusetts Peace Officer Standards and Training Commission. This is a public proceeding and proper notice has been provided. We are convening remotely via Zoom, and this pre-hearing conference is being recorded. The Honorable Kenneth J. Fishman will be the presiding officer over today's pre-hearing conference. My name is Lizzie Smith, and I'm the hearings administrator for the Post Commission. This matter is now before Judge Fishman.
All right. Good morning, everyone.
Good morning, Your Honor.
And if just for the record, if counsel would state their appearances, please.
Good morning. Sean Martinez for the Division of Standards.
Robert Stowe on behalf of Robert Devine, who's present with us today.
And good morning, Mr. Devine. All right. So we are having a status conference 2 months ago, approximately. We last met for status conference primarily because of the discovery issues that were ongoing. And I guess, why don't you start with Mr. Martinez, if you bring me up to date?
Yes, of course. So Mr. Stowe and I spoke before the conference. I let Mr. Stowe know that the only discovery that we anticipate would be relevant to this hearing would be if his client were deposed in the civil case. At this stage, we don't believe that that has been the case, and the deposition, in fact, hasn't been scheduled yet. Otherwise, the division just asks that Mr. Stowe provide any documents that he expects to introduce at the hearing on his client's behalf. But otherwise, we don't anticipate that there will be too much discovery overlap other than what the division is already in possession of.
Okay. And is that, what's your assessment, Mr. Stowe?
Well, that's a correct statement. We did have a conversation. There is no deposition scheduled of Mr. Devine at this point. We had continued the matter because I think in part there was a 1 terabyte hard drive that was being provided to us. I talked with Amy Bratskier for the city of or the town of Stoughton, and she had to get an IT person to download the information from the drive that she received from the police department. The council are having that problem getting the information. Is curious, and I discussed this with Attorney Martinez, who's been very forthcoming about the information he has. And I've actually received more information through the post files than I have through the terabyte hard drive that I got from the town, from Stoughton itself. So we're still trying to get access to that. I don't think the 1 terabyte hard drive is going to add anything to what I understand is the Post's case in this matter. I think the Post is essentially limiting themselves or limiting this case to some Facebook messages made by named Marty Riggs that are allegedly attributed to Mr. Devine, as well as a prior violation of a prior reprimand that Mr. Devine had. We're going to have 2 witnesses in the case, but I think I have a duty to my client. I don't think there's going to be anything in that 1 terabyte, but I have a duty to my client to at least access it to see what else is there. As I said, the city's attorney, who represents the police department as well, she couldn't get access to it, and I'm gonna call her today and find out what the IT person said, because I was able to access some information on the 1 terabyte hard drive, but not all of it. So that's where we are. I would suggest.
Well, what's being represented to you about the sort of in a broad category, the nature of the material that's on the terabyte?
It's 2 exhibits that are part of the report that's led to Mr. Devine's leaving the department. So 2 exhibits, and it's a complete computer dump of from her computer onto whatever drive there is. So my understanding is 1 terabyte equates to 252-hour movies. I don't think there's going to be anything on there based upon what I've seen so far, and based upon my knowledge of my client's claim that is going to inculcate him into anything.
Right, particularly given now that you understand the scope of the division's case at this point, right?
Correct. And Mr. Martinez has been very forthcoming about the discovery he has. My suggestion is we do a very short date, maybe like 2 weeks. I can reach out to the city, see what they've done with their IT person. We have a final pretrial conference and we get a trial date. If it's appropriate at that time, that's my suggestion. I
Well,
just
let me ask you this. Let's go away from discovery for a moment. Mr. Martinez, are there any, and I remember the original submission when we had our initial preliminary hearing, but are there any motions that you're anticipating, any legal issues that we're going to have to address in advance of the hearing, ultimate hearing?
I believe that most of the legal issues will be whether or not Mr. Stowe and I can agree to authentication. I expect that we'll be able to do so, especially given that, Mr. Stowe may have received similar materials in 2 different cases. I don't expect authentication to be an issue, but that likely most of the issues that would come up in pre-hearing would be that, I believe, would be whether or not Mr. Stowe would like a witness to, for example, authenticate the information that's on the terabyte, or the text messages or anything like, or excuse me, the Facebook messages, anything like that. I don't anticipate that pre-hearing there would be much more than that. I really do think that it would likely be authentication, and I hope that we'll be able to come to agreement on what's admissible and what's not in advance of the hearing. But again, just given the overlap between the 2 cases, I don't expect authentication to be too much of an issue.
All right. And while you have the floor, do you anticipate that what Mr. Stowe is trying to retrieve now from the city or the departments, that it's duplicative of the material that you've had and provided?
I expect that it will be mostly the same materials. However, I don't know if it's if post records are complete. I do know that when we requested the IA materials, Stoughton gave us represented what they believe to be the entire IA record. I do also know, however, in the civil suit that there are records possibly for the Massachusetts State Police that may be incoming, and that may contain more materials than what Stoughton had even for their IA.
And Mr. Stowe, from your perspective, do you anticipate once the discovery issues are finally resolved and you've reviewed the material, that there are any legal issues that need to be addressed before the hearing?
I would have a motion to eliminate regarding hearsay. The crux of the post-commission violation, the second violation, has to deal with allegations that a Facebook messages or Facebook posts by a Marty Riggs were attributed to Mr. Devine. We contend that is totem pole hearsay. I don't know if totem pole is correct to use that term anymore, but it's duplicate. It's multiple hearsay, and authentication would be needed for that to come into evidence. So that is definitely a live issue. My client denies that he made those postings, so that's an issue in this case. He's been adamant about that throughout.
All right.
And my understanding is that the crux of the second violation, or alleged second violation, is that this Marty Riggs person, who is a pseudonym for Mr. Devine, had these communications with while he was on the job. That's my understanding, is that's essentially, that is their case, that these Facebook posts were Mr. Devine and they were made while he was on the job, and that's what was inappropriate. So that's a big issue in the case.
Okay. All right.
I'm sorry.
No, go ahead.
As far as the state police goes, there was a keeper of record deposition done for the state police. We did have a hearing in the interim. We were trying to get in the civil suit, we're trying to get the records from the Attorney General's office. The judge ordered the Attorney General's office to give her the records. The records, I understand, were delivered on or about the 12th of this month from the Attorney General's office, who has compiled records from the state police. And those are in camera review. They're before the judge right now for review. We have no idea what's in there. A keeper of record deposition formally done to the state police. resulted in the state police saying we don't have any. And when the Attorney General's office, when we filed the motion to get the records from the AG's office, the AG said, yeah, well, we have the state police records. So the state police tells us we don't have records. Attorney General's office says there are. The judge is looking at those records and reviewing them now.
Which judge is that?
I don't have that in front of me. I could probably look it up.
Yeah. At one point, I remember one of our status conferences, somebody was talking about Judge Jackie Cowan, but I don't know if she's still involved in that case.
I don't know. I think they changed judges. It was originally Judge Davis.
Right, I remember that, right.
Then it changed, and I don't know if I wrote her name down.
That's all right. That was more curiosity than anything else. But well, let me ask you this as a practical matter. It's one thing to be waiting to be getting full access to the materials from the city. Is this issue about state police records also an obstacle to proceeding?
Well, I think I see I'm in this predicament where I have a duty to my client to investigate information.
Sure.
So on a practical level, from what I understand about this case, my client's denying culpability as far as the second matter goes. I don't see it as an obstacle, but I have a duty to my client to investigate it to see if it is an obstacle or if there's something in there that might be exculpatory. I know that in the underlying case, there were three, in the post has or had cases against three individuals, three officers. One of them has resolved. Those cases involve some 57,000 text messages, none of them of which involved my client. Those 57,000 pages, I'm sorry, of text messages. I understand there are even more in the post filings in that 1 terabyte. I don't know that they involve my client. I'm sure they don't. But as I said, I still have a duty to investigate it. And if the state police has reference in their records, which they might, because they're investigating it further, I have a duty to look at that as well. I will point out that something has been a very unusual change in circumstances in the underlying civil, well, not the underlying civil case, but the civil case, is that on June 18, the plaintiffs in the case claimed now that it wasn't a negligence case, that Ms. was overcome by emotions which resulted in her committing suicide. They've now gotten a forensic expert, a Dr. Baden, who has opined that now it's a homicide. So at this point, I've talked to the counsel for Ms. estate, and I said, listen, you've got two different claims here. As a matter of law, they can't coexist. You have a negligence count and you have an intentional tort count, and there's case law that says they can't coexist in a judgment. You know, which is it? And curiously, he won't even tell me. He doesn't know yet. So civil litigation has been going on for a year. Plaintiff's counsel doesn't even know what direction it's going.
Well, just from seeing the public report of it,
right?
So the so-called Dr. Baden's revelations are relatively new, aren't they?
Yeah, June 18th. That's when they came to light, and then counsel actually gave them to the press. Plaintiff's counsel gave them to the press, which I said, well, I'm learning more about it by watching Facebook. Not Facebook, by watching YouTube than I am in the case I'm representing somebody in. Where am I getting that information from? Why am I seeing it online? And they told me, one of the responses to me, we gave it to the news. So
here, I guess here's my concern in terms of the post proceeding. You've mentioned, in 2 weeks, hopefully by then they've conquered the IT problem with the material you're waiting for from them, from the city, and you've get a chance to review them, and that there's nothing that causes you concern that you've got to go down another road, get other material. But now I'm hearing about the material provided to the court for in-camera review by the Attorney General's office.
Yes.
I'm also, if I'm correct, hearing you say that you'd be uncomfortable proceeding without doing the due diligence that would include your review of that material as well. At least that which is made available after in-camera review.
Yeah, well, there's two directions we're going at in the Sill case. One is the in-camera review, and there's another keeper of record deposition that was filed by counsel for Matthew Farwell for requesting the state police records. So that's coming up, I think, next week for the production of that.
So my question is, if these things hanging out there, are you anticipating that even if you resolve the material from the city, that we're still going to be waiting?
No, I think if we get the state police records, or I just have the ability to go into the 1 terabyte, and I'll tell you what I was fortunate about in getting the materials from Attorney Martinez was that the PDF file, for example, with the 57,000 pages of text messages, is a searchable PDF. So I can go in and put my client's name in, and I can go through 57,000 pages in a matter of minutes versus sitting down and going through 57,000 pages. And a lot of pages you do go through, but there's nothing really that comes up. There's certainly no conversations or communications by him under his name or any other reference that I've been able to find or research. So I anticipate that, or hoping that's part of the terabyte that I can go through it, and it's not a lot of the videos we've been seeing right along. I think if there were videos that showed Mr. Devine in them as part of the terabyte dump, that would be something included in the state police report or in the post report. But there are videos, many graphic videos that it's just disturbing to watch. But I have to look at them and watch them because I have to make sure my client's face doesn't pop up at something. So I found nothing, and I've talked to other counsel that have gone through them all. As I said, there's 3 other attorneys besides myself looking at this information, and we're all working together and sharing information as to what we found, because there's a lot to go through. And nobody's found anything that's popped up on the videos so far that has shown any faces of any individuals that are involved in this. So we're kind of all working together trying to get the discovery. But I think it's a state police issue right now. I'm sure Attorney Bratsky has been able to get access somehow to the 1 terabyte. If it's searchable, I'll be able to search it in one day. As far as the state police, that's kind of the red herring, not the red herring, but it's kind of the jump ball. But since there's been no indictments, and since there's been nothing added to the post report, to the any of the reports we've seen or the investigation materials, that I don't see it arising. But you never know. As I said, there might be something exculpatory, but in this case, we're kind of confined to, and correct me if I'm wrong, Attorney Martinez, to the Marty Riggs Facebook posts on the second, as far as the second case goes.
Yeah, I believe that that's correct. I believe that that's correct.
So let me ask you this. In terms of being able to make progress, it's important to both sides, I think, to get this ultimately addressed. And on the other hand, I am, as you know, sensitive to respondent's right to have his counsel review all relevant discovery in advance of the final hearing. But it occurs to me that we ought to consider, let me know if you object to this approach, excuse me, scheduling a final hearing date far enough out to envision that the discovery has resolved, that we have a final conference, that we can address the few motions relating to admissibility that may be out there. But at least we have it scheduled and a goal, so that it just doesn't languish at this point. I think.
Right.
Do you have any problem with approaching it that way?
No.
Okay.
No.
So let's think about an approximate date, Lizzie. So what do we have? We're in August.
If I may ask, Mr. Devine, would you like to have any input on that matter as far as kicking it out to a final date?
No, as long as I can fit it into my book, I'm fine with that.
Okay. Well, let's talk about a date, file day, and work back from there. How far out are we scheduling hearings at this point, Lizzie?
We had a pre-hearing conference earlier this month and we scheduled a hearing in November for one of the other cases. So we scheduled pretty far out.
So that actually accommodates the circumstances in this case well to be doing that. So
Yes,
It actually is the other officer involved in this case.
oh, is that right?
Yeah.
Okay. When is that scheduled for?
The-
November
November
19th.
Um, later in the month, perhaps?
The following week, I believe, is Thanksgiving.
Yes.
I'm gonna be a real softie and not schedule it for Thanksgiving.
Thank you. My wife thanks you.
Yeah, right. Looking here. So that's on the 9th. Wait a second, did you say 9th?
The 19th.
19th, I was gonna say.
Yes.
Unless we're doing hearings on Saturdays. Well, how about then, since that's Thanksgiving? How about the either the first or second weekend of December?
Either week should work for me. If we do that first week in December, just again, given the holiday, I think I'd prefer later in the week.
Sure.
But then that second week, any day should work.
The 11th, 12th, and 13th work for me from the second week.
All right. Well, and having done that, I can't imagine that we're not going to be able to resolve any discovery issues in that lengthy a period of time. So
I agree.
And how many witnesses are we talking about overall? Do you anticipate?
I anticipate Mr. Devine, and we have 2 other witnesses.
And for the division?
I would expect at most 3 or 4. And I don't know. We may call Mr. Devine on our direct case as well. But I would not anticipate more than that, and it may be fewer if we're able to agree ahead of time on admissibility of evidence.
So let's do this. I always sort of plan for the longest possibility. So why don't we schedule it for the 11th, Lizzie, if nothing's in the way? And then if for
Sure.
any reason, either witness availability or length of hearing, we need to go into the 12th, we have the opportunity to do that.
Yep. And did you want to do 9:30? Is that a good start time?
Is for me, unless anybody's got a problem with that.
Oh,
No.
No,
So we'll need the so it's 9:30 on December 11th. Then working backwards to a conference date before that. So if issues arise that require time between that and the trial, I'm thinking even again, because we've got several months now available, perhaps the week of November 11th.
that sounds good.
That should work.
November 11th is a holiday. It's Veterans Day.
Yes, absolutely. And the 12th is a holiday too. It's my birthday. So let's, I'm sure it's on your printed calendar somewhere.
It is. It just popped up.
So either the 13th or 14th, Lizzie, does that work?
Yeah, either of those dates work.
All right, your choice, counsel. You have a preference?
Being superstitious, I'll take the 14th.
That's fine.
But I would
And
like
also
that.
at 9:30, sorry.
Yes, please.
Okay.
And then let's, I do like your idea because I don't want to be surprised, and even though I'm happy that you two are staying in good communication, it's exactly what you should do, and I appreciate the fact you're doing that. but I'm out there too, so I want to make sure that that we have no surprises leading up to this. So I would think that let's do a 30-day status. So I make sure that these lingering discovery issues have been resolved, and if not, if we need to take some kind of action, that we have time to do that. So we're at August 20 now.
September 20th? Friday?
Actually, I've got a conflict on that date. But the 19th would work.
19th works for me as well.
The 19th is the commission meeting
Yes, we
for,
do have a
September.
commission meeting.
Well, what about the 17th?
that's fine.
17th of September.
17th at 9:30.
Yes, that works. As for the hearing December 11th, that'll be in person downtown, I presume?
Yes, yes.
Yes. good.
Yes, that'll be held at the post commission office, and I'll send more details closer to that time.
Great.
So they're not using the civil service place anymore, right?
Not anymore, no.
Oh, good. All right, 17th. If there's an issue that you think requires our intervention, for instance, an inability to get some records because the Superior Court is holding them, or the AG hasn't produced them, or whatever, our IT is having problems, you know, the other material you're waiting to access. Why don't you submit something in writing first, and perhaps you'll, even if you both agreed on what to do. I just don't want to get to the point where we are addressing it and not leaving ourselves adequate time to get the material to you, to have an opportunity to review it, and unnecessarily delay the proceedings in this case. So again, if there's no issue, don't worry about it. I'll learn about it at the status conference. But if there is an issue which you think requires intervention on our part to obtain material, why don't you advise me in writing on that?
Certainly.
Okay.
If I may,
Yeah,
one
sure.
question. I anticipate having to have 2 subpoenas. Is those subpoenas a request for the commission to issue those subpoenas, or how procedurally, how do I go about getting those subpoenas for these independent witnesses we want to bring in?
How have we been doing that so far?
So, councils have been issuing subpoenas. I believe it's chapter 38, section 12.
Yeah.
I believe is subpoena practice. What attorneys have been doing is having them notarized, which I believe makes them valid subpoenas under 30A. But they've been CCing both the members of the division and post C review when they send the subpoenas.
Okay.
Check that statute.
All right. Is there anything else you want to discuss today?
Nothing for the division.
I'm content.
Okay. All right. Thank you, everybody. We'll meet next on September 17th, and hopefully by that time you'll have received everything you want and have adequate time to review it as well. All right.
Thank you, Judge.
All
Thank
right.
you.
Thank you.